The Expropriation Act, which has been the subject of much discourse over fears surrounding expropriation without compensation, will be tested in the Western Cape High Court soon. Despite the Act triggering false claims of current land grabs or future land grabs in the country, this contested element or debate does not form the basis of the Democratic Alliance's challenge of the Act. The DA, however, will bring a constitutional challenge that is rather based on the process preceding the then bill being passed into law, as well as certain clauses which the DA will argue do not meet constitutionality, which the DA states is a strategic move.
Well, in this court challenge, we're following the strategic advice of our lawyers. And our lawyers are extraordinarily good strategists. We very rarely lose a court case with them. And they have said to us repeatedly, if you're going to challenge something in court, do it on the point in law that is the quickest, easiest, and most direct. And what they've said to us is, yes, while you in principle most strongly oppose opening further doors to expropriation without compensation, your very easiest and direct line to a potential victory is to challenge the process whereby this act was supported by various provinces in the National Council of Provinces. So we listened to their strategic advice, and that's what we're doing.
The challenge includes two grounds: procedure and constitutional flaws in Section 19, Subsection 2 and Subsection 3. The DA pokes holes at the process leading up to the Act being passed by contending that of the provinces that voted for the then bill in the NCOP, only 2 validly voted, and that 5 final mandates were conferred contrary to the Constitution and the Mandating Act.
The principle of negotiating mandates is very clear. In order for any province to come and vote in favor of or against an act or a bill, they need to have held their respective legislature sittings. We know that Gauteng, the Eastern Cape, and Limpopo did not do this, and these are the points of contention that we have. They're questioning the 7 out of 9 majority vote, which in fact tallies to 4 out of 7.
In addition, the DA zooms in on Section 19, Subsection 2 and Subsection 3 of the Act, arguing that it creates an ambiguity in the expropriation because an authority can issue a notice before compensation is determined, and also allows the same authority to issue a notice after a court deals with the dispute. The party argues that this section is irrational, and the party seeks to invalidate the Act in its entirety. The first respondent cited in the DA's challenge is the Minister of Public Works and Infrastructure, who must implement the Act. A post which is occupied by the DA's Dean McPherson, who shared his views on X, formerly known as Twitter, where he maintained a strong opposition on the expropriation of private property. It remains to be seen how the first respondent will respond to this constitutional challenge. Kani Mapanga, SABC News, Johannesburg.